Ladies and gentlemen, can we reconvene, please? I'm happy to say that over the brief break, I was handed a number of questions, and there's an obvious concern over some aspects of what the speakers have been talking about. And when we come to the question and answer session, we'll deal with those questions as well as others that you may think of in the interim. We would now like to move on to an aspect of this of Rule 77 that is not often, or has not in the past often been used, and some new provisions that Richard has spoken of in his comments. And before we move to that, I'd like to introduce to you my co-speaker on this topic, Madam Justice Wilson. And as you may be aware, she's been a member of the bench since 1992 of the Ontario Court General Division. She practiced in litigation with the Blaney Murtry firm and with the Bastido Cooper firm for a number of years prior to her appointment. What is most important, and what she wanted me to emphasize in introducing her, is the commitment that she has had to case management and has since prior to 1991. And she, together with Justice Kiteley and Justice Koo, has been dogged and determined that civil justice in Ontario would move quicker and more in a less costly way than it did before. And in large part, her efforts have been singular in bringing into place the case management system in Ontario. And I'd like you to welcome Justice Wilson to this topic.
Thank you. Kevin is all too modest, and he's been a dogged participant for many, many years in the Operations Committee, and Justice Kiteley has been, for every hour I've spent, she's spent at least an hour. I've had the benefit of participating as a lawyer in helping design the original system. I was one of the case management judges when we had the individual calendar back in the beginning, and then I participated in the transition period to the case management team. So I have had the benefit of at least seeing the evolution from both sides. As Justice Kiteley said, it has been over-managed, and what we're trying to do is to identify and retain the best features of case management while simplifying and defining responsibilities so that it's less onerous for both the bar, for the judges, and for the court administration. In my view, some of the salient features of case management have perhaps been underutilized. And what I'd like to do is remind you, go back to the purpose of the case management system, which is in Rule 7702, which is to reduce unnecessary cost and delay, facilitate early and fair settlement, and bring cases that required expeditiously to just determination while allowing sufficient time to process the case through the system. The emphasis, I think, in case management is finding fair solutions early and at a reasonable cost, and streamlining the cases that need to go to trial, because some cases can't be settled and have to go to trial. A new feature that we hope to introduce when we have our case management master appointed is some early screening. It is the belief of the case management judges that case management as it presently exists is an improvement over a laissez-faire kind of approach. But it doesn't go far enough. The feeling is that when we see the cases, whether it's at a pretrial conference or at a motion, often precious time and, more importantly, precious resources have been depleted. And it is the belief and the desire of the case management judges that there is a need for early screening at the close of pleadings. And we are hopeful that the master will participate in this. And it's, I think, the decision of the case management judges that our new master is going to have limited time, and we'd like to see this person participate in some early screening, and the judges, for the meantime, may well continue doing master's motions or jurisdictions within the jurisdiction of the master as a trade-off. And the objective of early screening, the exact form has not yet been worked out, and we have to wait till the person is appointed, and there will be consultation with the bar, with the committee, and with the person who's going to be doing it. The objective of early screening is, again, to promote early settlement where possible, to explore ADR options, if appropriate, before you get into discoveries, and identify the cases that may benefit from early judicial intervention and assistance. It is the belief that canvassing settlement early and encouraging use of offers to settle may well facilitate the whole purpose, which is reduce cost and delay, encourage cases to settle an early point in time. And again, to identify the cases that can really benefit from some hands-on work. So even though we've gone from a system that started out as an individual calendar that moved to a team system, there is a belief, I think, and a desire amongst the case management judges for the right kinds of cases to encourage some hands-on case management. And there have been some accommodations in our schedule, and as Justice Blair has said, it's important that case management be part of our regular day and part of your regular day, and not going on into all hours of the night. So the plan is, I think, that each each judge on the case management team will have one day, perhaps one day a month, and as necessary, more if necessary, to schedule continued appointments, so that for the cases, the difficult cases, the thorny cases, the ones that can benefit from hands-on work, that will be a feature that's available and in fact encouraged. And this early screening by the case management master should assist in that. It is our belief that the time invested of a master in the early screening and early conferencing is time well spent. A point I was talking to Kevin yesterday about how to approach this. We've come a long way. I've seen huge changes in perspective, both of the members of the bench and members of the bar. There is, and I think probably the motor vehicle bar has to be congratulated, because I saw them to some degree as warriors or cowboys, depending on your point of view. But I think I've noticed the biggest change amongst that group, and I think perhaps it's because of their mandatory arbitration provisions, that a lot of those cowboys are now sitting as arbitrators, and there's a real sense of ownership, a real sense of problem solving that I don't think was there until some of these other provisions were in. And having said that, I compliment some of the bar, I compliment some of you in this room for taking that kind of a responsible problem-solving approach. I think we still have a ways to go. I was talking to a young lawyer today who was telling me he was going to spend $12,000 on a $10,000 case, and that he wasn't going to let an insurance company push his client around. And I sort of said this, but this isn't a war. You know, your client may have some exposure, and to spend $12,000 on a $10,000 case, you know, and anyway, I did order a conference with the clients to attend because it seemed to me that that there was a little lack of perspective. So I think we've all come a long way. I've noticed a huge change amongst the judges and amongst many of the bar. We still have a ways to go. The focus is on early fair settlement and on streamlining those cases that need to go to trial.
Let me make a few observations, and Justice Wilson is the first one to have observed or brought to your attention Rule 7702. And in point of fact, if you look at Rule 7702 and you try to apply it, you ask the question, in whose interest are you bringing the case? It is not your case. It is not the judge's case. It is not the administration's case. It's your client's case. And all of those, and you may call them motherhood phrases if you wish, all of those aims and purposes and goals are driven by one desire, and that is to satisfy a problem, solve a problem that your client has, either as a plaintiff or as a defendant. And surely, as lawyers, we should first of all be concerned about protecting and enforcing and ensuring that our clients receive the access to the system that they should. And so to a large extent, case management, in my view, and from my personal experience with it, because as now an absolute converted member of the case management system, and I was somewhat uncertain when I first became involved in the operations committee, I know it works. I've had some very complex cases that have seen themselves resolved in a very short period of time, comparatively speaking, to days of yore in the regular non-case managed list. And I've seen difficult cases get to trial much faster through the use of what is now in place in Rule 77. Early screening, which Justice Wilson talked about, and which we hope will take place when the case management master is appointed, and as we begin to get a sense of the volume that the 25% is going to create initially. It commences on the filing of the first defense, and you should simply be aware that of the provisions of Rule 77093. It's on the filing of a defense. Note that that's the controlling step in case management. You can issue your claim, you can file your notice of commencement of action. It just sits there, it's just a piece of paper, it's just a number in a computer until there is a filing of a defense. And I'm not going to walk you through the definition of defense, but notice that defense is defined and it includes a number of documents that are not simply a statement of defense. So that's that point in the process, and you know that it's 180 days after the day you start your action, because that's the key time frame. At that point in time, it's going to be the case will either be dealt with by the team of judges who deal with case management, or maybe assigned to an individual case management judge if that is possible. That determination will be made, in my view, based on the provisions of choosing what track your case will be on. When you issue your notice of commencement of action, you're going to have to choose fast or standard. By and large, most of you will choose the standard track, except if perhaps it's a simple collection action or something of that nature, you will choose the fast track. But if you consider the provisions of Rule 77.06 sub 6, those are the factors that should be taken into account in determining whether or not you are in a standard track or fast track situation, so that you're looking at complexity. Is this a straightforward, simple breach of contract, or are we into breaches of fiduciary duty and negligent misrepresentation and all sorts of other wonderful causes of action that currently are in vogue? Is it likely to be an expensive case? The expense factor, to my mind, is not as important in considering the track as the complexity. The importance of the issues. You may have very small amount of money at stake, but a very important issue for the public at large, and therefore may wish to consider in those circumstances whether or not this is a case you might be able to get in front of a single judge for case management purposes. The rest of the shopping list in sub 6 is quite clear. The number of parties. If you're going to have a multi-party case with many counsel involved, you're certainly on standard track, but those are the kinds of cases through early screening we're hopeful will be directed towards a single case management judge. So those are factors that we believe will ultimately be important in the screening process. And I was asked during the break about whether or not you can opt in to case management. The simple answer is no. If you're not one of the randomly selected computer numbered 25%, you're not going to be able to participate in any of the available remedies and processes that are contained in Rule 77, but you're not entirely without a remedy if you believe that case management or some form of case management may be of assistance. You can always keep in mind that Rule 3715 does allow for the appointment of a single judge to deal with matters in a complicated case. It used to be, before Bev introduced the computer selection of cases, it used to be that if you had your clerk stand at the 145 desk and made sure that it was case number 10 that was there, that you could sometimes help the system choose a case for case management. It sounds like Bev has cured that little situation, and we're no longer going to be able to do that. But at least the percentages are up. Let's talk about three of the other, what we perceive are really important parts of case management and why this system works. Richard talked about the rule. We want to talk about the practice, and it's case conferences. It's Rule 7713. We're not going to walk through the terms of that again, but Justice Wilson will give some overview from the judicial perspective of what case conferences are designed to do and what can be accomplished at a case conference.
What I'd like to do actually is talk about, if it's okay with Kevin, sort of three areas, which is what's a case conference, what's a motion, and where should we be using conference calls, because to some degree they intertwine. Case conferences, I think, is one feature that has been underutilized by the bar, and it's probably one of the best features of case management, and I think it's probably just because people haven't really realized it's there. At any time, a party may ask for a conference. This was in our old rules. Very few people do it. And at any time, a judge may order a case conference. And at a case conference, a judge has a power to make an order. So it would be easy enough to fill in a Form 3 and ask for a conference, which is a less formal setting. You can have your clients there if you wish. You can probably deal with your procedural point in 5 minutes, and you may well make progress in narrowing the issues or forging out some sort of discussion towards settlement. I think it is important that if you are going to take advantage of the case conference provision, there is no requirement in the rule for a special form. And I suppose that was done deliberately to see how it evolves. I certainly suggest, though, that you think about what your agenda is and write it out. So not necessarily with, I want to spend 5 minutes on each issue, but what are the issues that you want covered in this appointment time, and how can the time be used efficiently? But I think it's a very underutilized provision, and particularly when there are powers to make orders, you can, in a way, combine some organizational issues, some procedural points, and some narrowing of issues, and even sometimes getting into some settlement discussions or some preliminary, how could we go about solving this. You may not get into actual settlement discussions, but you might define mechanisms by which the issues could be narrowed to move towards settlement. And it is the view of the bench that we would like to encourage these conferences and reduce the number of motions. The motions and case management, it's lawyers only. It has evolved. We did it, as you probably remember, when we had individual times and we encouraged people to come into our offices. We found that just administratively was chaotic, and to some degree it was combining a procedural motion where somebody may want the formality of being able to stand up, gowned, and argue a point of law with a settlement discussion, and let's sort of figure out what's going on here. So what we're trying to do is, we still think there's a need for motions, and they should be, excuse me, for important matters. And unfortunately, what we're finding is a lot of unimportant matters where people are stuck. And for instance, I had one yesterday on my list where they thought they were going to take an hour and a half deciding who was going to be examined for discovery and where. Now, it took, a very short period of time, and But that's, number one, it should have been dealt with by a conference call. You know, you do not need a courtroom and your gowns and bringing people in and waiting your turn for something like that. And number two, counsel, I mean, this is getting back to the issue of problem solving. It isn't a war, and if you can't sort out who's going to be examined in what order with counsel, you're going to have a heck of a time settling a lawsuit. It was certainly indicative of a case that needed some management, and that's what in fact happened. But as I see motions, a lot of the procedural matters can be dealt with by conference call. That's another facility that's, I think, is excellent. It's underutilized. And then the important motions, you know, come to court, serve your factums, make your arguments, and deal with your points of law. That's sort of how I think the judges would like to see the division, and encouraging people, though, to use the case conferences for early settlement. It can be your agenda, and it can include some sort of order. Don't mix a complicated question of law with sort of I want to get organized kind of motion. That's not, I don't think, an appropriate mix. But I think those three areas are very important. I'm not sure that the time is being used wisely by the bar. And I would encourage you to think about a case conference. Think about using conference calls for procedural motions. And I guess when I'm seeing the kinds of problems counsel are running into with each other, I guess it's just focusing on, as Kevin said, whose case is it, what's the purpose, where are you going, and whose money are you spending? I don't know if you've got any comments on that.
Just a couple of points. Case conferences, I have found from experience, are very helpful in the right case. If you've got a multi-party case or a complex issue case, case conferences are very useful for sorting out your basic timetabling. If you've got a complex case, you may not be able to achieve the kind of timetabling that we're hoping will be the norm under case management, the 240-day rule. If that's the case, this rule is flexible. It's designed to accommodate those unusual situations. Our experience in case management to date and tracking endless statistics and analyzing many of the glitches that we perceived over the last several years indicated that a flexibility element is key. That's what the case conference can do for you. And there's no magic to it. Bev's hotline numbers, you call them up and say, I want a case conference on this case. When can we be accommodated? It's just that simple. And while, you know, there's always a problem because we've all got busy calendars, you will find a date among counsel when it's available. And if counsel on the other side do not come prepared or do not come readily, I've been in situations where the case management judge has made it quite clear that counsel will attend and are quite prepared to deal with costs as a sanction to ensure that a case conference is effective. And so either as plaintiff's counsel or defendant's counsel or third party's counsel or whatever, please use the case conference mechanism that's here because it does work. If you look at, and I don't want to read the rule, but it's very interesting in my view of it. The rule is done in a very flexible way. The matters to be dealt with at a case conference, the word is explore methods to resolve the contested issues. Just start considering other options than what may have been on the table. Explore, I thought, was an interesting use of English here as opposed to consider or perhaps some other words that might have occurred. And so the case conference can benefit you greatly in any number of different ways, from sorting out the scope of production and, you know, doing production in phases, doing liability issues and then damage issues. There's all sorts of things that you can accomplish at a case conference that, in my view, you can't accomplish in the ordinary non-case managed scenario.
The only point that I'd forgotten to mention is that I think that the intent, certainly in Toronto, is that for all motions, even if it is a formal motion, that the case management motion form be utilized, and that the idea that you don't have to have formal orders issued and entered, unless it's a situation where a lawyer feels having a formal order is important. I mean, the idea still is to use the case management form and the order so that the judge signs it on the spot, copy is given to counsel at the time, or faxed back. You know, that system, I think, is one of the features of case management that has worked well, unless, of course, for some reason, a formal order is desired by counsel. So I just wanted to emphasize that.
There was one question, actually, that was given during the break. Is there any limit on the number of case conferences that you can have? I'll let you go first on that.
Well, I don't think so. I think from a practical point of view, what may well happen is if you appear on a case conference with a judge, and if you are making progress, what often happens is these things is you'll get a series, you get a to-do list, basically, that, you know, you've found perhaps an approach of finding some answers to the questions of litigation that makes sense to both sides, that's cost-effective. And what may happen is that you work out a schedule of what's going to happen. Are you going to hire an accountant? How are you going to approach things? And then set another date before the same judge, assuming that you're making good progress and the judge is on, you know, is being helpful. You can ask for that, and that will be encouraged. And as I said, the idea is now that the judges will have a day a month to enable them and to encourage them when they've heard something to assist if they can assist further. On the other hand, you know, you people have to do your job, and we're not here to run your cases, and we can't. You know, we're here to help when the going gets tough, but we can't be available to help with every case. We don't have the resources, and ultimately we have to be there to do the trials, because, you know, if we don't have trial judges there, the system collapses, because to make a credible case management system, you have to have timelines, going to a trial date, and then have a trial judge in a courtroom available. It's all kind of part and parcel. So I'm saying we're available to help, but that doesn't mean you people shouldn't do your job and be narrowing the issues and having conferences amongst yourselves. I'm still stunned by the number of times people come to what we have jumped to the next thing, which is the pre-trial conference, settlement conference. The number of people who haven't talked about settlement, and they've gone through all the steps in the proceeding, they haven't served any offers to settle, they haven't taken advantage of that huge protection, and there's not a lot of money at stake. So, and that's one of the disadvantages of the judges becoming proactive, and it's still a debate amongst some of my peers. By the judges assuming responsibility, does that mean the lawyers abdicate? And so what we're trying to do is encourage everybody, and particularly the bar. I mean, it's your case, it's your client's problem. And as opposed to a litigation solution, finding a practical solution that works for your clients is the best way out, and the sooner the better.
Let's turn to settlement conferences, because they have a slightly different makeup than the standard pretrial conference, which all of you have been through under the current rules. The settlement conference is seen as a key step in this process, and that's why there is a time limitation attached to it, the 180 days in the fast track, the 240 days in the standard track after the delivery of the first defense. And the key is to get there. We have discovered in the course of tracking cases, as we have endlessly in the pilot projects. I brought this along. It's I think you can see it from wherever you are. It's got a blue bar and a red bar. This was tracking these were tracking cases in a 6-month time frame. The blue represents the disposition of the case-managed cases. The red represents just your same old, non-case managed. It is 41% in the red. It is 88% in case managed. So the system works, and it works because you get counsel and clients looking at their case, not just waiting for a pretrial notice or something to come in 2 or 3 years after you've issued your claim. It is, in fact, a response to taking a look at the case, a hard look at the case, and deciding where your risks are, where your client's risks are, and what the benefits are, perhaps, to some other form of resolution. And since we all know memories fade with time, I much prefer having a witness in the witness box maybe 2 or 3 years after the event rather than 7 or 8. The system is designed to try and achieve that. So come settlement conference time, I think that one of the biggest changes is the documentation that you're required to file for a settlement conference. It's no longer just a 3-page quickie summary that you toss off 2 days before. You're going to have to think about it and plan your case, and whatever else, in my experience, it's an excellent planning exercise for trial. You actually have to formulate your issue and think about what witnesses you're going to need and what they may say, and do all of those things, and you're going to have at least an outline, a good outline of where your case is going to go should it go to trial. So your settlement brief is going to contain much more than what you're used to. And you can, I analogize it in large part to the compendiums, and if you've done a lot of work on the commercial list, you're familiar with compendiums, you know that even if you've got a 5,000 document case, there's only 5 or 6 that are going to make any difference at the end of the day. Those 5 or 6 should be in your brief. You know that there's a couple of passages in the discovery that are very helpful to you. They're going to be in your settlement brief. And so you can build up your best case and put it in a nice little package for purposes of the settlement conference. And again, the onus here is on us, the members of the bar. The system's there for us to use for the benefit of our clients. It's a persuasive step, participating in a settlement conference. You are trying to persuade the settlement conference judge or master that you've got the better case and that your client deserves to have the case dismissed or achieve the damages that are being sought. So as an exercise in persuasion, the settlement brief becomes a very key part of it. And so you're not limited. There's no, as again I say, flexibility is one of the keys to this. You're not limited to what you can put in there and what you can put before the judge.
I guess I just want to reiterate what Kevin has said. Even if the bar is warrior-like in motions court, and even if they don't look at the early settlement option, please, 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 by the time you come to the settlement conference, have completed your discoveries and be ready. If in fact you don't, you want to get on with your case, and as I said, we all know there's some cases that have to be tried. Have your discoveries completed. Have your documents exchanged so that it can be meaningful. Because that's where we've had some difficulties with the case managed system where things we've given 8 months. That was, we as Kevin has said, we statistically analyzed how long people were taking, what extensions were being asked for. We added that time in to allow the 8 months so that people would have enough time. So what we ask is that please, when the settlement conference, you're going to have 45 days notice, be ready so that it's a meaningful experience for your clients and for you. Clients can attend. It's certainly not in any way mandatory. I think the judges are open to that if it's appropriate. Sometimes it's most useful to have a first session with the lawyers, and if there's difficult clients, once the lawyers have worked out with the assistance of the judge some parameters of a recommendation, then meeting with the clients. But as I said, there is facility in the rule to open up that option, and I think if that's what you people think is best for your case, then that is quite possible. A settlement conference is going to be more than just a settlement conference. And I think it's obvious when you look at the list of what has to be included in your brief, because it includes a list of the witnesses and sort of a will say statement. That's not just to know what the case is about. That's also to get a handle on how long the case is going to take, because you're going to be setting the trial date at your settlement conference. And it's very, very important that we know accurately how long trials are going to take. And one of the things we found it brings the system to its knees is if counsels say with a straight face that it's going to take 5 days, and it turns out it's 5 weeks. And that creates huge disruption for the system, for the team, and ultimately for your clients for the next case. So one of the things that we will be canvassing at the settlement conference is how long is it really going to take? How many of these witnesses do you really need? And when you've actually got a list of the witnesses, you have a much better idea of how long that trial is going to be on an accurate basis. And as well, there will be discussed at that settlement conference, if you can't settle it, okay, how can we proceed with this case in the fairest, most expeditious manner? Can you look at requests to admit? Can you look at requests to admit supplemented by an affidavit with some cross-examination? What are the issues that you actually need viva voce testimony? How can the issues be narrowed? Because I think when we talk about the next thing, which is the trial management is polishing, if I can put it that way. It's, are you ready? Have you got all your ducks and drakes lined up? But trial preparation, if it's a difficult, complicated case with a lot of documents, you can't turn it around 14 days before trial. It's like trying to turn a ship in the middle of the ocean. You need more time and more lead time than that. So I think you will still find that at the settlement conference, certainly the focus and the primary focus is going to be on settlement, but a secondary and important focus is going to be on how long is this going to take, so an accurate timeline is given for the trial date, and how can it be organized in a way that's most effective for you and for your clients.
And that leads us to trial management conferences, which are a new and unique element of the case management system. And it's Rule 7715, which sets out the provisions of trial management conferences. If you haven't participated in one, I commend them. You are now required to do one. You're not required. It says may be held. Let me say that in my experience, in the two cases where I have done a trial management conference, they are a very helpful exercise. And particularly if you have a somewhat complex case, it is certainly to your benefit to have a meeting with the trial judge prior to trial to sort out housekeeping matters. If you just think about the average trial you've been to, how much of your first day do you spend doing housekeeping? You know, who the players are, what's going on, the number of documents, the briefs, the exhibits, all of that kind of stuff. You can do it in a trial management conference, organize those kinds of things and get the housekeeping to a minimum so that day one of trial, you really start a trial, not just simply chat about what's going to happen over the next couple of days or couple of weeks. The trial management form at 77D is a simple form, but is an interesting form in that it again compels you to isolate that which is important to your case. And the form was drafted deliberately with a view to those working from the experience of those who had been involved as to what was really important at the outset for the trial judge to be able to deal with. And so if we walk briefly through this form, the first item is issues outstanding. You may have started with 5 or 8 issues in a case, and as a result of discovery or whatever, you have determined that you haven't got a hope on 3 of those issues and they're just mere surplusage and they ain't going anywhere. So why waste your client's time and money and the court's time with issues that aren't going to make it? So you're really forced to look at what is the key issue to the case or key issues and isolate them and articulate them. The damage issue, it's always going to be a problem, determining what the damages are. Items 2 and 3 are interesting because they deal with, I guess counsel don't like to be cornered on these two headings. But item 2, plaintiff's witnesses. Trial by ambush, theoretically, disappeared many, many years ago. I know that all of you have had experiences where trial by ambush is still in existence. By and large, we are trying to reach the stage where trial by ambush is completely eradicated. There should not be 4 or 5 days before trial any surprise as to who your witnesses are going to be. Occasionally happens in the course of a trial. You need somebody that you didn't think you need. Sure, that happens. But the core number of your witnesses should clearly be known to you within the first 10 days of trial, and if they aren't, then maybe you haven't been looking at your case very carefully. So this is designed to at least give the trial judge a sense of the number of witnesses, not asking for, this isn't a settlement conference. You're not going to get talking about, well, we made this offer and they won't take this or whatever, because you're not going to want to taint the trial judge in any way whatsoever. What you are trying to achieve is a realistic assessment of what's going to happen at this trial, and avoid the slippage that Justice Wilson talked about, the good old 5-day case that becomes a 5-week case. So our estimates of examination in chief and cross-examination, they will always be off. It doesn't matter how much we think we are accurate in saying we'll be an hour and a half or 2 days with a witness. It's always going to be wrong, but at least it's going to cause us to focus about the importance of what their evidence is and what they've got to say, and give some clearer senses to timing. Same for defendant's witnesses. The defendant will say, of course, well, I don't know what witnesses I'm calling until I hear what they've got to say. I've got 10 on my list. I may only need 4 of them. Fair enough. But at least say, I know I'm going to call 4, and there's a potential for another couple more. Items 4, 5, and 6 are also of assistance to the court, the document brief. And what I found very helpful is that your sort of compendium of key documents, perhaps if you've got a large document case, may very well be something that you prepare and provide to the trial judge. They're going to be exhibits at trial. You're not going to taint the judge in any way by providing that. So those are things that are going to be very helpful at the outset.
Just one comment about the trial management. This is not something that I think is unique to case management. There are some initiatives afoot that this kind of process take place across the board, and in fact, the regional senior justices in all the region are thinking about how we might better manage our trial process by having trial management conferences. So this is, interestingly enough, perhaps was precipitated as a result of case management, but may have broad application sooner than later, which I think for all of us is good news.
We've covered the main topics that we wanted to cover. I'm going to invite Justice Kiteley and Bev Eldridge to join us at the podium for a question and answer session. I've received 4 or 5 questions from you. I've got a few of my own, and we'll deal with these, and then we'd be very happy to try and cope with what other questions you may have thought of. Certainly. We're going to trade them.
Having introduced this by saying we were overmanaged on the last one, forgive me if I'm reading a few minds by you people thinking, well, now we have all of these blankety-blank forms. That sounds like more management. What I think you'll find, though, is that you'll settle to avoid filling out these forms, because you will know how much trouble it is to know your case and understand it, and you much prefer to get on the phone and make the case go away. So the hidden agenda is, by making you do more work, you'll settle it sooner. There's a question.
Yes.
Considered the problem where a person's acting in person, are they going to still be required to follow these rules?
Yes, and we were talking about case conferences earlier. Bingo. If you've got an in-person litigant, you're going to want a case conference, because there's no other way you're going to control an in-person litigant without having a judge read the riot act. That's my view of it. I'm not getting...
And the judge may well want a court reporter there.
The one thing that we find it difficult to do is telephone conferences with in-persons, but they are going to have to participate as well, and case conferences are a good way to do it.
During the break, I was passed a number of questions, and let me run through these quickly, and we'll provide our views on them, and then take some further questions. We were asked, if an action is settled before a notice of defense is filed or a defense is served, is there any special formal notice required to be filed to advise the court of the discontinuance of the action or the completion of the action, or are we simply relying on Rule 7708, which is the 180-day dismissal section?
There's a real easy answer to that. Send in a Form 3.
77C.
Sorry.
It's now 77C.
Old habits die hard. The case management form, all you have to do is certify, you fill in the blank, settled, have it discontinued. End of the case.
Regarding the transition rule, where there's no statement of defense before February 3rd, but it's filed within 80 days, 180 days, who fixes the settlement conference? Is that automatic, Bev? Is that that automatic comes from your system?
Yes, if a defense is filed within the 180 days, that was the question again?
Yes.
Yeah, yes, it will come from us.
There is a provision in Rule 77.06 sub 4 that I received a question about, and we'll see if we can come to some understanding of it. The question is, what constitutes a further step requiring the filing of the originating process? Under 706.4, it provides that an originating process shall not be filed until some further step, other than the filing of a notice of discontinuance, is taken in the proceeding. My view of until some further step means that some third party has requested a copy of the document. It may be a member of the press, or it may be somebody who has an interest in knowing what is going on in that action. All right. Justice Kiteley disagrees with the question.
The further step, with all due respect to Mr.
I
Aalto,
thought it was making it up on the spot.
is a motion for default judgment, in which case you have to file a statement of claim, a motion to strike out a defense. I mean, the further step is basically some form of motion. There has to be then a pleading in the file.
Is that?
Sorry,
Sure.
you expected then to file the originating process and then your motion record with the originating process in it, or you okay to file the originating process in the question?
That's a very good question.
Obviously, we haven't.
I think you could do it either way. I don't think there'd be any requirement for it to come in after the motion or before the motion. If you're doing a motion, you know you're going to need to have it there, so bring it in at the same time would be the easiest thing.
But I think the
Now-
question is, the sub to that is whether it comes in this hand by itself or in this hand in the middle of a motion record. If it's in the right hand, then it's going to go into the computer as having been filed, whereas if it's stuck in the middle of a record, it might not. We have talked about doing a question and answer bulletin, and I think this sounds like a good one.
It is that.
Look
I'll make
forward to
note.
the answer. And in the meantime, file both in the record and separately.
Supplemental, are motion records going to come into the office and then come back to the parties after the motion is heard? Or are they going to stay in the correspondence?
If everybody heard the question, just as we don't want any pleadings, when we're finished with a motion, are we going to give it back? That hasn't been done yet by the Rules Committee, but there's certainly a move afoot to give you back all of your motion records, including your briefs of authorities, because we don't need them. It's part of a paper storage problem. If there's an appeal, you've got them all, and you can certify the appeal record. So while there's lots of judges that give back books of authorities, I don't know anybody who yet gives back motion records, but it'll come. Of course, when we go to the e-file project, for those of you who are in e-file, then you won't file any paper.
And there will be a record of your motion and the result in the file, obviously, because of the form of motion that's there. It's the backup documents that we're anticipating will return. Another question that I received during the break was, deals with Rule 7710, and whether or not there is in fact a distinction between a case management master and a judge in Rule 7710. And I think we are into the grounds again where this is a novel question that none of us have yet put our minds to. It may very well be that in sub 2, case management master might also exercise some of the powers that are there. But I'm not entirely certain, and that is a question that we will have to leave for further deliberation of the Operations Committee. One of the other questions that arose was, well, what happens if you're not ready? You know, this is a personal injury action. It's a back problem. It's a whiplash. It's whatever. It's going to take 3 years before we know what the heck is the outcome, what the prognosis is. What do we do with that case? I don't practice in that field, but my answer very simply is the case conference. You get a case conference, you explain it to a case management judge. Case management judge see these kinds of cases all the time. They understand that difficulty, and they simply amend the timetable. That's part of the provision. And so Bev's supercomputer is not going to knock you out of the box at 240 days or whatever. There will be an accommodation for that in the system, and there already is.
The rules are made for the normal case.
Whatever that may be.
The normal case.
You tell us.
But it's not for a brain injury.
No.
It's not for a fatality. But you know that when the claim is issued or you're filing a defense. So you know when that settlement conference is supposed to come along. Don't wait until the week before the settlement conference to do something about it. As soon as the pleadings are in, have a case conference, develop your own timetable, and move that settlement conference to a place where it really belongs.
Yes.
I actually have two questions, partly regarding the settlement conference as well. If the supercomputer here automatically sets up a date, I'm assuming that if you get a note and it says you're on X date and you're already booked in another court somewhere, there's provision for adjourning that to an acceptable date to parties when they're available. Because otherwise you're going to end up having bookings in 6 different courts on the same day. Cloning of a sheep is all I know.
Yes, but right now on the 10%, people get their notices as much as 3 months in advance. And if you know 3 months in advance that you're double booked, then you do something about it 3 months less 2 days. It is unbelievable how many people do it 3 days before the pretrial. So yes, there's flexibility, but do it as soon as you get the notice. Don't wait for the conflict to develop subsequently and say, golly gee, I'm unavailable. But we recognize when we automatically assign dates, there has to be flexibility. How do you go about moving it? You get the consent of the parties and you do a 77C, and you certify what's happening, give the explanation, and ask for the time frame within which you want it to be moved.
My other question, I guess, is more directed to Ms. Eldridge, and no disrespect meant, but there was a mention in the introductions that resources had to be committed to this in order to get it to move. You may have a supercomputer, but do you have enough people to ensure that when you put in an order, the paperwork doesn't get lost, and you don't find out what's happening, or that if something's supposed to be faxed back to you, it actually does get faxed back to you?
I would say yes, we have enough resources. I would assume your question means you've had experience where we haven't had enough resources. The fact that we don't have to send out as many notices and babysit in the same way has freed up some staff time right there. The computer is going to be doing it for us. We're not going to have to be sitting there manually saying, what do I do with this case now? Those sorts of things. So I think you will find that we definitely are in a position to not have those problems that, yes, I understand too, were occurring. They won't continue to occur. Eventually, of course, in our case management unit, for those of you who actually go to the court, we have one end of our counter that we call the case management unit. We have 4 counter workstations available there, and all of our staff, though, will eventually rotate onto the counter in case management, and of course, as we go to 25, 50, 75%, you won't just be going to that one wicket or those 4 wickets, you'll be going along to any counter clerk. And could I just mention one thing that I should fix while we're talking about what the supercomputer will do? I left you with the impression that applications would be excluded by policy even after the sustained program starts giving us the numbers. It won't, the applications won't be excluded at that time. Once we get into windows for sustain, that will be late spring of some time, then applications will be included in case management.
Can I do a quick supplementary on that? I was part of a group before February 3rd where Regional Senior Justice Lang, before we got wholly into the rules, insisted that there be a look at the staff. And we actually did a, what do you call that per year? Manpower? It's not manpower. That's
Workload indicators?
Workload indicators to see how many people, because over the move and in the winter, the lineups were, shall we say, modest. And Justice Lang wanted to make sure that that problem didn't compound our problem. And additional staff was put into it. As Bev says, some of the things we're doing are going to reduce their need. You talked about entering orders. Can I just reinforce? Go to tab 1, which is the rules. At the top of the page, 30. This is the case management motion form, where the judge writes in how the hearing method, which is usually in writing on this, and how long it took, and we check off one of those 3 boxes. The norm is that orders do not need to be signed and entered. When you think of all the orders that you slavishly draft, slavishly get approved, slavishly dump in the bucket, and then slavishly follow up trying to get them back, most of them aren't needed. And in case management, generally speaking, the judges say you don't have to do an order. So there should be a big workload reduction both for you.
That is the order. That is the order.
Yeah, this is the order. Once we make an endorsement, it's the order. Sorry, there was a question back.
There's a whole bunch over there.
First question relates to the expert reports and how that applies to the settlement conference. If I read the rules in place for settlement conference, it seems to be an instant implication that the 10-day rule is now extended so that you need to deliver your expert report by the time of the settlement conference. Is that going to be cast in stone, or the 10 days will still apply? And if the other side doesn't apply, how do you get your reports done in time so that you can have a meaningful settlement conference?
That's a matter that's being looked at the Rules Committee. I think it's going to change. You're right that right now the 10-day rule is the rule. From a practical point of view, if you don't have your expert reports at the pretrial, it's a waste of time. So I think what's going to happen is you should be prepared with your expert reports, or at least a summary of what they're going to say. Because sometimes it's very expensive to get the final thing with all the charts and so on. But at least a summary of what it is they're going to say and what positions they're taking for the settlement conference. Otherwise, it's not a meaningful experience. It's a waste of everybody's time. And I think what's going to happen is that the rule will change.
Yes.
When a non-party requisitions a copy of a pleading, is the party notified as to the identity of whose requisition the pleading?
Well, they'll be filling out the regular requisition form, and I believe that's a signed form, so you'll see the name. I don't know if there would be any formal identification. The court will be sending you the form asking you to comply with this request that we've had.
But does the registrar say we have received a request from
They'll send the form.
X? Or just we received a request, send it in?
We were planning to send the form.
The requisition.
Yeah, with maybe a covering memo, and actually we hadn't anticipated that you'd really be interested in knowing exactly who was asking.
Well,
Yeah, I can understand that, right, yeah. Well, It will only be a matter for your interest, because you'll have to comply no matter who it is. But I can see where you'd want to know.
There's no enforcement.
They'll soon make an enforcement,
Well,
though, right?
don't
I mean,
forget
they'll
that-
soon be
yeah.
doing motions.
The third party will have status to
Yeah.
bring an enforcement procedure.
Oh, I agree, but
Yes.
you can tell whether somebody would or would not do that.
It's a nightmare.
The public, it'd be better that their identity be just as if I were to go to the counter now, they don't need to know that I'm there with them now.
Well, you put your claim into the court file now. It's available for anyone to come and see. You don't know who's coming to look at it.
Maybe it should remain that.
Yeah.
So I look at, I mean, as litigants, we look at other pleadings, we're not just concerned about who looks at ours, but we're
Mhm.
looking at others.
It's a good point. We'll take that under
It may be
advisement.
the storage saving is not worth it. I mean, the design is to save the storage space of all these claims. It may be that it's an initiative that doesn't, maybe that there's more staff cost than storage cost.
This gentleman up here,
I have two questions concerning electronic filing. Number one, is it going to be possible to file motion records and sworn exhibits electronically? And secondly, will it be possible, in addition to filing stuff, to be able to obtain stuff from the court electronically?
Since this is case management, I'll give you the shortened answer to that. The e-file project, which is starting later in the spring, will concentrate only on pleadings at the outset because of the signature issue. Once we get the pleadings going, the working group has committed to focus on affidavits and tackle the signature issue. That will be some months hence in our lifetimes. Can you get stuff back from the court? Can you view, was that your question? Can you view by e-file?
That's right, obtain electronic copies of stuff.
You can if you go to the courthouse. You can get them off the computer there.
It's now after 6 o'clock, and I don't want to test people's patience this late in the day. But if you have some questions, and I know there are a number out there on the floor, the group down here are happy to stay for another couple of minutes and chat and try and answer questions. Thank you all very much for coming.
Thank you.